This is Nigeria at 57 in need of a rebirth. And, of course, you might have guessed, but maybe you haven't. We're having an extension to the program because of the quality of the conversations we've been having on the various subjects. The program ought to have ended thereabouts now, but we have executive orders to extend by 30 minutes. Takes us to 7:30 for this final segment. And it's on that note that I'll turn it over to you, Ijoma.
Yes, and I have with me some very distinguished gentlemen in the house, or shall I say with us here. I have a former Solicitor General of Lagos State, Mr. Fola Afawari. Thank you for joining us on the program.
Pleasure.
Thank you. And also Senior Advocate of Nigeria and former Secretary General of the NBA, Mr. Dele Adeshina. Thank you for joining us.
Thank you very much.
And in Abuja, I have a Senior Advocate of Nigeria, Mr. Udechukwu Noroka. Thank you for joining us on the program as well.
Thank you very much.
And just in case you haven't guessed, we're looking at the judiciary for the last 57 years, with all the powerhouses that we have. So let me start off with you, Mr. Adeshina. How well has the judiciary been able to perform her role, shall we say? Let me just leave it like that and then we'll get into it.
Well, thank you very much. I would say within the available resources to the judiciary, within the context of the problems that they have, both constitutional and systemic, I would say the judiciary has performed well within the period. Although there are rooms for better performance, there are rooms for improvement. The largest room in the world is the room for improvement. But within the context of the problems, both systemic and human, the judiciary has performed well. And if you want me to highlight some of these problems, I will say so. When you look at the Constitution itself, the Constitution is a problem. And I have said this over and over again when each time I have the privilege of appearing here, that the system, the constitutional provisions for the judiciary has brought in its own delay. And until we remove the delay occasioned by the constitutional provisions, the delay will continue to exist. I'll give you an example. Section 6 of the Constitution established the judiciary. And now you have, at the state level, you have the high courts of the state, you have the Court of Appeal at the federal, you have the Supreme Court at the federal. When you look at the high courts in the state, in the 36 states of the federation, plus the federal high court, we'll be having courts in excess of 250. And at the Court of Appeal, we have only 16 judicial divisions. And after Court of Appeal level, we have only one Supreme Court. By the nature of our people, for reasons I don't understand, 85% of our judgments in the High Court go on appeal to the Court of Appeal.
Because we're very stubborn.
Is it the nature of our people or the system that has allowed us to be so?
No, nature is the nature.
It will only mean that
it is the nature. And I'll give you an example. It's the nature of our people. For example, even after some of our people in this country have fought to the Supreme Court, they will leave the Supreme Court and still be looking for avenues to ventilate their disagreement. Yeah. We have not really seen anybody, but particularly in political cases, that we say, yes, although I disagree with the judgment, but I accept its finality. We are not ready to accept finality of our judgments. And it is not right.
But nobody goes there on their own. Legal counsel are also the ones that...
No legal counsel goes without being briefed.
But they do go. So you can't...
Without being briefed? No.
And what I'm saying is, if you say it's the nature of our people, what about the nature of the legal counsel backing them? You can't go to court on your own.
No legal counsel goes to court without being briefed.
But they advise the clients on what to do.
Of course, yes.
They have to. So if you advise your client that this is the final thing, so please just allow it go.
Allow it to go.
Do they do that?
Do they do that?
There are instances, some of us advise our clients that, look, with all the law that I have seen and the decision in this matter, I think there's no need for you to appeal. And some of them have taken such decisions. Some of them will still say, no, I want you to go ahead. The lawyer must accept to go because the principal is there.
Let's bring it as a way.
The principal.
Do you think the Constitution is a problem?
Perhaps it's one of the problems, but there's no perfect structure. I think that if we take the starting point that we this received law, received judicial system that we wisely or otherwise decided to adopt, is in itself complicated. The procedures, the rules, the appellate system, the structure, the argument, motions, application, it just takes it on. And then to make such a system workable, you need very strong governance. You need very strong administrative structures. You need resources, and that's where we're weak. I think we concentrate too much on the judge, but the judge can only be as good as the administrative system that backs him up.
What kind of resources are you talking about?
I'm talking about automation, not creating special courts, which will merely replicate the same problems, but creating automated systems that relieve him of the burden of this writing is ancient. It's the monks that used to do it. It's ridiculous. Even in Parliament, we have Hansard, we have writers. Why are the courts not, these are, for me, basic things that we need to have gotten on top of a long time ago. Again, also, I think a judge, it's like this recent special case, special courts. The court, special court is not going to improve the quality of the case.
Is it a special court or judges designated to handle?
It's the same thing, designated, whatever. You are still saying, yeah, so all right, let's say designated judges, whatever you have. It's still within the same system. What you are looking for is speed of process, right? And for me, unless the governance of the courts are weak. The administrators, the registrars, and so on, they're not managers of processes.
Doesn't the ACJ address the weakness?
It probably could try, but as my friend Dele has said, the system is very widespread, and a lot of the problems are local problems. For instance, the NJC cannot resource the Lagos State Judiciary in terms of its clerical staff. Judges are these days made to type their own judgments. Go and find out. They don't have secretaries. They don't have clerks. If you can't deal with these basic problems, then you're not going to get output. This is, so my issue is the system we adopted is complicated, right? That's why you have to go to the law school, learn all the rules, etc. And then the record keeping and recording process cannot keep up with the sheer scale of our litigators. We're a very litigious society. We litigate everything.
Which is what Mr. Adeshina
so the Constitution may be one aspect, but I think we're weak in most of our institutions. We're weak on these governance issues. We're weak on administration issues. We're weak on resource allocation and management. And unless we deal with this critically, we're not going to make much progress. That's my view, and I speak from a level of experience.